The question is that the motion be agreed to.
Mr. Speaker.
Porter Williams.
Thank you, Mr. Speaker. Firstly, Mr. Speaker, can I commend the Government Administration Committee and the work that they have done in ensuring that Part 3 of the Statutes Amendment Bill was able to be examined on its own after some significant issues were raised by the community sector. And in that regard, I also must commend Huia Community Aotearoa for their ability to read through those particular provisions in the Statutes Amendment Bill and flag with the committee that there were some issues that the wider community would be really concerned about, and actually sought to have the ability to submit on that process. I just want to defer to my colleague, the Honourable Ruth Dyson, in that as I go through my contribution to this piece of legislation, there are some technical parts to this which I might not get exactly right, and I hope that she will take the opportunity to ensure that I do actually have this correct. So, Mr. Speaker, the Minister was right in her comments about ensuring that the community and the charitable sector actually has some trust and confidence in the Charities Registration Board. And I think that sits at the heart of why we are here today and why we are discussing this particular piece of legislation. Because it was a Court of Appeal decision that kind of started the conversation about the ability for certain charities to have the right of appeal to decisions. And that further provided the opportunity to have some examination of the particular clauses relevant in this bill. And I'm going to use the departmental report as my reference in my contribution today. And I do want to start with that case on appeal, which was regarding whether the Foundation for Anti-Aging Research and the Foundation for Reversal of Solid State Hypothermia were eligible to register as charities. And why I start there, Mr. Speaker, is that this kind of sits at the heart of a lot of the discussion, the ability to register as charities, and therefore the ability to be deregistered by the Charities Registration Board once you have registration. So this was cited as, and along with other examples, as one of those cases where the Charities Registration Board would take a particular view about what constituted a charity. In the discussion on this particular bill at Select Committee, even though it was slightly out of scope of the bill, it actually formed an important part of the discussion, because sitting at the heart of appeals to the High Court by charities is their ability to remain registered. Those are the reasons that charities actually seek support from the High Court, because they have been deregistered by the Charities Registration Board. So, Mr. Speaker, the Court of Appeal decision involving a particular submitter to the committee cited interpretation of sections 59 and 61 of the Act, and the consequences of amending section 59 to include appeals against decision of the Chief Executive of Charities' ability to complain to the Office of the Ombudsman. And further to that, Mr. Speaker, in the departmental report, the department notes that the court's observation reinforces their advice about the proposed amendment to section 61 to remove the words "or the Chief Executive," which was going to correct that drafting error, but it does not remove charities' right of appeal, as one of the submitters stated that it did. But at the heart of this is the level of trust within the sector that was actually going to be the case. There is a significant amount, I guess, well, there is an amount of discussion in the sector about charities' ability to appeal any decision that the Charities Registration Board makes, and that the high threshold that is required by having to take a case to the High Court. And we have heard the examples that were made, such as the National Council of Women, where the test in those cases was whether providing services specifically for women and around gender equality, for example, was actually charitable purpose. If we had had the ability to have a review of charitable purpose, as was promised when the original legislation was first enacted, then perhaps that level of trust in the community and the charitable sector would be such that we would not necessarily be at this point where we're having to take Part 3 out of the Statutes Amendment Bill to examine it separately, to provide some opportunity for the sector to comment and to have that faith restored, which is exactly what we're doing. Further to that, there was a real sense of that the charitable sector would actually be impacted by not only decisions made by the board, but decisions made by the chief executive. Now, during our discussion, the department was very clear in their response to say that there are no statutory decisions that are made by the chief executive. However, the charitable sector, specifically the submitters to the committee, were concerned enough about that they wanted to ensure that the words "or the chief executive" were removed from section 60, I believe. What actually happened in the end was that the decision was made by Labour and the Greens to say that section 61 in its entirety should be removed. Clause 61 should be removed, and that would provide certainty to the sector that those decisions around the chief executive decisions would not go on to impact them, and that was in fact done. So for Labour, the discussion was around restoring some faith and some trust back into the process for charities, because there has been some damage done in that relationship between the charitable sector and the Charities Registration Board, and this is seen as an opportunity to actually have that conversation, to start restoring that relationship. Mr. Speaker, just in conclusion, I want to say that if we had had the review that we were promised of when the Charities Commission was devolved, when Charity Services came on board and the Charities Registration Board took over the process of registering and also deregistering of charities, we probably wouldn't be needing to discuss this. And I'm very grateful that Huia were vigilant enough in the Statutes Amendment Bill to signal that there was a problem, that they wanted to have the opportunity to provide comment on the legislation, and therefore actually provided an opportunity for other charities to make that comment. Mr. Speaker, we are supportive of the work of the committee and hopeful that at committee stages we'll be able to examine these clauses further. Thank you.